Mr. Datar was.
Before lunch, I was at Article 213. And what I wanted to mention was that gives us a rough idea of the scope 200. Please come to Article 213. And I read clause 1. If at any time, except when the Legislative Assembly is in session, or when there is a Legislative Council in a state, except when both houses are in session, the governor is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinances as the circumstances appear him to require. Now, this ordinance is done on the satisfaction of the Cabinet of Ministers, Council of Ministers. They say matter is very urgent. Ordinance has to promulgate. He promulgates it. But in the proviso, because the ordinance is going to straight away become the law, there is no stage of bill being passed and so on. What happens is, provided that the governor shall not, without instructions from the president, promulgate any such ordinance if a bill containing the same provisions would, under this constitution, have required the previous sanction of the president for the introduction thereof into the legislature. He would have deemed it, number one, there are multiple sections, Mr. Supremecourt cited them, 31A, 31C, where you require the previous sanction of the president. B, he would have deemed it necessary to reserve a bill containing the same provisions for consideration of the president. And C, an act of a legislature containing the same provisions would, under this constitution, be invalid unless, having been reserved for consideration of the president, it had received the assent of the president. So, in the case of an ordinance, the governor is cast upon a duty not to promulgate the ordinance if ABC are satisfied. Now, in Krishna Kumar, what they say is, if the legislature is in session, then he has no such duty. The governor need not wait for instructions from the president, assent to the president. Even if a law is repugnant, please see Krishna Kumar para 38. What I'm submitting is, as my friend Sadan also put it, a bill is not repugnant to any particular provision. A bill is not void. It's the law which is passed which becomes void. So at the bill stage, there is no repugnancy. The president or the governor can warn and say, look, if you pass this bill, this could be the possible consequence. If the state legislature goes ahead and does it, it faces the consequence of being struck down as either ultra vires Article 14 or 254 and so on. Now kindly come to Krishna Kumar's case, para 38. They emphasize this point quite well. Volume V37 at page 1403.
Where have you dealt with this point in your written submission? Which page?
Pardon me?
Page,
No, it's
it
230.
more the weekend.
No, 213. I actually, yes.
You said that it's
No, I said send the submissions. Then I was re-going through it. Then they said it's already been filed. So
already said it's
I'm making an amendment for it. My apologies. So when I went to 213, then I saw Krishna Kumar also. Kindly see page 14103. Para 38, where they reproduce 213. I'll skip that. Lordship has got 14103.
Now 103.
Yes. Para 38 starts with Article 213(1). V37. Then the Supreme Court discusses how these three conditions apply, and then the passage is important. May I proceed now? The first of the above conditions arises in a situation such as the proviso to Article 304B of the Constitution. Under Article 304B, the legislature of a state is permitted to impose reasonable restrictions in the public interest on the freedom of trade, commerce, or intercourse with or within that state, notwithstanding anything in 301 and 303. The proviso requires the previous sanction of the president before a bill or amendment for the purpose of clause B can be introduced in the state legislature. An illustration of the second requirement, point 2 above, is provided by Article 200 of the Constitution, under which a governor is required to reserve for consideration of the president any bill which would, if it were to become a law, derogate from the powers of the High Court so as to endanger the position which it is desired to fill the Constitution. Situations where assent to the president is required, point 3, are illustrated by Article 254, where a law is made by the state legislature on a matter enumerated in the concurrent list is repugnant to a law made by Parliament. The state law will prevail only if and to the extent it has received the assent of the president. These three situations make it abundantly clear that while exercising the powers to promulgate an ordinance, the governor is not liberated from the limitations to which the law-making power of the state legislature is subject. Now please come to 200.
That's a, you missed two words, in his opinion.
Where?
In his opinion, you missed.
No, 1 second.
14103.
Must be inadvertently.
No, 1 second. Wait a minute. Yes, which in his opinion, yes. Any bill which in his opinion were to become a law derogate the powers. I'm coming to that, in his opinion. Now kindly see. His opinion will be the president's opinion. Here in this case, which is reserved for the consent. Now, my lord, the point I'm trying to make is this. And my entire submission is that the governor has only options, he has no discretion. That's my submission in terms of Article 200. And I make
He has to exercise either of the three options.
one of the three options. And
He has no discretion.
no discretion is my submission. And I'm deriving support from this because what are the limitations of the state? Same apply in an ordinance. But now kindly see. Suppose a bill is potentially repugnant to a parliamentary law in list 3. A bill is potentially repugnant to a parliamentary, contrary to a parliamentary law. Now, can the governor say that I will not assent to the bill because it is in the teeth of a parliamentary law? Now, my submission is the only ground on which the governor can suo motu refer the bill for the consideration of the president is the second proviso, where it derogates from the power of the High Court. So if a state legislature is doing something which is going to derogate the power, he need not act on the aid and advice of the state government. He can say that this is going to derogate from the powers of the president, of the High Court. Therefore, I'm referring it to the president. Second proviso is an exception to following the aid and advice of the cabinet. Now, kindly come to 254. Suppose, my lord, I'm giving an example, because if your lordship sees in the judgment of the two-judge bench, the reasons given by the governor was, if I pass this bill, it would lead to serious degradation in education standards. Many bills were educational bills. So he has given comments as to why he is not giving assent to the bill, because that bill will be contrary to entry 25 of list 3, or it will be contrary to entry 66 of list 1. All that is given in the two-judge bench. Now, my submission is, even if the bill in the teeth of it, I gave the Maratha reservation issue, even if the bill in the teeth of it is repugnant, what happens is my submission. Kindly come to 254 now. Kindly come to 254.
Yes.
Now, first come to 254.2, then I'll come to 254.1. Now, my lord, in most legislatures, when they make the law, it is often done with application of mind. They see the provisions, particularly if it's a concurrent list item. The first thing you will see whether this is going to be in conflict with a central law. That's the first thing you see. Now, let us say the state of Tamil Nadu wants to make a law which potentially could be in the teeth of a law made by Parliament. But it wants to have that legislation for the state of Tamil Nadu. What will it do? It will tell the governor that this is the bill I am raising. This potentially may be in conflict with the existing parliamentary law. It could be an Industry Development Regulation Act or an Essential Commodities Act and so on. Then the state cabinet tells the governor, please refer this for the assent of the president. Then it goes to 254(2). If the president gives the assent to the bill, then insofar as Tamil Nadu is concerned, though it is inconsistent with the law made by Parliament, it will be valid law for that state. That's why you got Stamp Act amendments, you got CPC amendments, you got Hindu law amendments and so on. State-wise amendments are there. Now kindly come to 254(2). Where a law is made by the legislature with respect to one of the matters enumerated in the concurrent list contains any provision repugnant to the provisions of an earlier law made by Parliament or an existing law with respect to that matter, then the law so made by the legislature of such state shall, if it has been reserved for consideration of the president and has received his assent, will prevail in that state. So the state legislature, the state cabinet can request the governor, please send this to the president for his assent so that this law in the concurrent list will prevail in Tamil Nadu or in Karnataka, or as the case may be. Suppose the state does not take the protection of 254(2), it makes a law. It says, I don't want the governor to refer to the president. Then it will run the risk of 254(1). Kindly see 254(1). If any provision of a law made by the legislature of a state is repugnant to any provision of a law made by Parliament, which Parliament is competent to enact, or to any provision of an existing law with respect to one of the matters enumerated in the concurrent list. So the state law can be repugnant to either a union list law or it can be repugnant to a concurrent list law. Then subject to provisions of clause 2, the law made by Parliament, whether passed before or after the law made by the legislature of such state, or as the case may be existing law, shall prevail, and the law made by the legislature of the state shall, to the extent of repugnancy, be void. But the point I'm making is, at the governor's assent stage, he cannot be a constitutional filter and say, no, I won't give assent to it because this law is going to suffer.
What you are saying is, state legislature is entitled to make a repugnant law.
An invalid law.
Valid law.
Yes.
Its survival depends upon operation of 254.
Yes. And again, you again get the thing that a law will be valid unless it is struck down by a court.
But the discretion, the question is the discretion.
Yes.
That the governor has under 213 for an executive legislation is unavailable for 200.
Yes.
The qualitative distinction is that under 200 it is passed by the legislature.
Yes.
Whereas under 213 it is executive legislation.
Yes. Yes, exactly. Because it's an ordinance. Because the point is this, ordinance is made by the cabinet. It doesn't go through the assembly. There the bill may be defeated, may be passed, may go amendment, debate, discussion may take place. So here what happens, the governor effectively has an additional role to play to make a scrutiny and find in an ordinance. Will clause 1, 2, 3 apply? If 1, 2, 3 applies, then he will not promulgate the ordinance without the prior consent of the prior direction of the president. That's my submission. So 200, my submission is, whatever may be the nature of the law, because how did this matter come about? The reason the governor withhold the assent was he's saying that this Tamil Nadu Fisheries Amendment Bill is contrary to entry 66, is contrary to this law, contrary to that parliamentary law. My submission is no governor in the country can be a constitutional filter. No governor can take upon himself and pronounce upon the potential validity of the bill and decide. Because at the bill stage, it's a bill. I can, as Justice Narasimha put it, I can pass a good law, I can pass a bad law. I take the risk. 99% of the cases, my lord, normally a state legislature will not. That's why your lordship sees any constitutional textbook. The number of laws which are struck down are not even 2% of the total number of laws made. The court says there's a presumption of constitutionality. then the court tries to save the law, it may even read down the law. But to say that, the state legislatures will be some kind of a Wild West situation, they can make any law. If the governor is not a check, then there could be rogue laws being made. Is only a chimera, it's a mirage, it's not correct. On a constitutional principle, I can make a law in my competence, and sometimes what happens, the legislature may genuinely feel within my competence, but the court may say to the otherwise. We don't know. So that's my interpretation on Article 200. Now I come to the next part of my submission. Now my submission is, there is no bar in laying constitutional timelines. If a constitution is silent on a timeline, and if in the course of time, a timeline is felt to be necessary, courts can do so. I've just given one example. Kindly see 2.1.1 my written submissions, PLR projects, where in the context of appointments, I've just given the extract. Your lordships have said that the IB should submit its report within 4 to 6 weeks.
Paragraph
2.1.1. Page 1121. Lordship will see in PLR projects, in the context of High Court appointments, the Supreme Court has said that the IB should submit its report within 4 weeks. Then how much time the central government should forward the collegiate within 8 to 12 weeks? Then how all those time limits have been sent back. Finally, it reiterates recommendation should proceed made within 3 to 4 weeks. Then kindly see 2.2. Dr. Rajendra Prasad, in his address to the Constituent Assembly, while moving the resolution for adoption of the Constitution, stated that the gaps that are in the Indian Constitution must be filled by developing proper conventions in due course. And I'll develop this convention point a bit later. So my submission is, if tomorrow, my lord, there is a provision, your lordship has done it on the statutes. In so many cases, at least as a tax lawyer, where no time limit is fixed for taking revision proceedings. In Bhatinda Power Project, Justice Sinha, in a very well-reasoned judgment, said that though there is no time limit, I'm putting an outer time limit of 5 years. If you issue the notice beyond 5 years, is that.
Restoration of land to Scheduled Caste and Scheduled Tribes Acts.
Yes, sorry, my lord.
So, Scheduled Caste and Scheduled Tribe Restoration of Lands Act.
Yes.
So, no timelines were provided for making an application for. The Supreme Court read it that though no timeline is provided, application has to be made within a period of 5 years from.
Yes, sometimes court says reasonable time, but lordship may see.
Now those acts have been amended
Yes.
to overcome those judgments.
Raghav. First is Raghav Natha, exercise of revisional jurisdiction under the land laws. And
Celebrated litigation of Gujarat High
he celebrated Patel Raghav Natha. And the court said when there is no time limit prescribed, it should be reasonable.
Reasonable. And that reasonable period has been read to be 5 years. Some of the.
I will go one step further.
Here in Raghav Natha, it was said 1 year, but that depends upon the statute in question.
Number one, I would be grateful. I'm saying sometimes the lordship may say go beyond reasonable and fix a time limit of 5 years, fix 3 years. Why keep it reasonable and keep it vague? Ultimately, the effectiveness of a law is its certainty and predictability. We are a large country of 28 states, 144 crore people are there. If Supreme Court lays down a law saying it is 3 months, 6 months, then there's complete clarity and certainty. Whether I'm in Meghalaya or I'm in Tamil Nadu or I'm in Karnataka. I'm just.
This court tried any number of times this concept of laying timeline.
Pardon me?
There is a season of medical season.
Yes.
The time when we have laid down the law, within a fixed time, no further admissions, all admissions will come to an end. Rumapal's order.
Yes.
This has led to, you know, how much of litigation?
True. No, there are pluses and minuses.
Time after time, we have laid down timelines.
Yes.
And every year,
Timeline has
every
never
year
worked
there are applications
successfully
after
now.
applications for extension.
Keep on extending time again and again.
It has
No.
created much more litigation than what it was earlier.
But maybe in education.
Learning from our own experience
Correct.
also.
But in education, it has created problems. In tax laws, the justice system has worked wonders. I mean, it could be from law to law. What I'm now submitting is The question is whether the court can impose timelines. My first submission is Supreme Court has imposed timelines from time to time in statutory provisions.
Constitution with statute also.
Pardon me?
Constitutional provisions stand on a completely
Yes,
different
my
footing from
submission,
that of a statute.
my submission, I agree, Lord. But the point is, suppose the constitution has not, in the initial draft, have not prepared a timeline. My humble submission is, in the case of constitutional interpretations, your lordship can always come to it. Take the basic structure from Shankari Prasad and Sajjan Singh, where you said that the power of parliament is untrammeled. That is the word used.
How much you are
Because of
pushing
time.
courts to do this?
Pardon
We
me?
will have state governments filing applications saying
Yes.
that we need some more time. And these applications will go to under 226 before the high courts.
Yes, I'm not saying.
And on the other hand, you will have applications by stakeholders saying that the time is coming to an end. Don't grant more time or give it a mandamus. Our fear is we are dragging the court into a situation where the legislative process is getting completely monitored and controlled through the processes of the court.
Lord, can I?
We are not at any point of time saying that there is expediency and there is a requirement for legislative process to be completed within a time.
Lord,
But to fix it on a time schedule, the biggest risk court takes more than anybody.
Lord, I'll put, we are concerned with Article 200. Lordship will just visualize Article 200. We'll forget education, taxation, land acquisition. Let's take Article 200. Lord, the draftsman has made it as soon as possible. He has given a clear hint that as soon as possible. Now, I ask myself the question, if as soon as possible is creating problems in a working situation, where, as just Mr. Venugopal said, in 23 states it is done immediately, in 5 states it's taking 6 months, 7 months, 2 years, 3 years. I'm asking the question, my lord, what is the power of the court to say as soon as possible shall mean an outer limit of 6 months? What is wrong with that? And what the court has not said, you must do it within 6 months. That's not what division bench says. Division bench says, if you don't do within 6 months, you can come to court for redress. That's what the division bench says, the 2-judge bench. But I am putting a proposition for lordship's kind consideration. Is the court's power is not fettered if they feel that as soon as possible is vague, is leading to. Sorry, Murad.
We are only answering the question, so.
No, I'm not. So I'm just saying what in the light of what Justice Narasimha said, in a constitution should be what can be done in a statute. Can it be done in the constitution? My submission is if as soon as possible was not there, then it was a completely different cup of tea. But where Parliament has said as soon as may be possible, they've used it in 62 election of a president, 68 election of vice president. They've used it in Schedule 6. So whenever they said as soon as possible, suppose during the working of the constitution you realize
Respect to such an expression, the courts will still have jurisdiction.
yes,
You can't have a constitutional logjam. And
Yes.
just because those words are there, it doesn't mean that we have a problem.
no,
It depends on.
No, I'm saying that, I'm putting it this way, Malone. There is a law, which is the statute. There is an interpretation put by your lordship. The law is X, your lordship's interpretation is Y. X plus Y becomes the Article 141 law. Ultimately, the statute says something, your lordships interpret that particular statute. Now, your lordship's interpretation on that particular provision as to what may be reasonable, what is the outer time limit, read both together becomes the law under Article 141. I am saying that this need not be a Article 142 power at all. Suppose your lordship finds as soon as possible. I am asking myself the question, however complicated the law may be, do you require 3 months to give a message?
Even if as soon as possible was not there, still the governor would be expected to act in a particular time,
Yes.
in a reasonable time.
Yes.
Correct.
So,
Even if as soon as possible was not there, as soon as possible says, all right, expediency is there. Without that, those words phrase also, there would be some expectation within a reasonable time,
Yes.
and normal behavior
yes.
from a governor to,
Yes.
when a bill has come to him, he has to do something or the other.
I'm building upon what your lordship is saying. I'm saying that when the constitution makers made it 6 weeks, made it to as soon as possible, they always contemplated a definite timeline. It can't be kept endlessly pending. And why? Because I've been elected on a particular mandate. So tomorrow, Tamil Nadu government may want to impose prohibition. The governor may say, no, this is not a good law. I'm not going to implement it. You can't do that.
Can't.
So my submission
Can't
is,
test the validity of the law. The government cannot test the validity
Yes.
of the bill, yes.
so I'm
So
only
the
saying,
correctness of that bill.
yes, I'm only putting as a proposition of law. If as soon as possible, the highest court of the land interprets say, as soon as possible will mean a period of 3 months, a period of 6 months. I'm not saying there's anything unconstitutional about
It
it.
would be an urgency, it would require 24 hours for the government to act.
Maybe, it may be. Some disaster is there, a tsunami takes,
Correct.
some.
Whatever.
Or as Mr. Venugopal put it, there is a money bill and there's an appropriation bill under Article 114. Now, money bill is under 111, appropriation bill is 114. Can you stop appropriation bill, pass the money bill and don't do the appropriation? Well, ultimately,
There
what-
could be situations, depending.
Lord, all these are components of a well-oiled engine, which is the government. Everything has to work together. You can't have one particular component not working in sync or harmony with the others. Otherwise, everything will break down. And what the Constitution contemplates is all of them work to the common goal of a particular government. A government has been elected. It has got the mandate of the people. The governor has to respect that mandate. That's all I'm saying. I'm answering my lord's question that can we impose a time limit in Constitution? My answer is yes. Lordships can. If lordships can lead basic structure into the Constitution, lordship has led substantive due process into Article 21. Why can't the lordship fix a time limit? If your lordships can go so far as to bring in substantive due process in 21, overrule A.K. Gopalan, why not? Then lordship first said 14, 19, 21 are separate. Then my lord said, no, all should be read together.
Trinity
These are
of-
all
Trinity of
Trinity,
19 and
yes,
20.
bank nationalization case.
Maneka Gandhi also.
Maneka Gandhi also. Yes. So I'm only putting to lordship. I'm saying there's nothing wrong in the presidential reference to ask, can the court do so? Answer, the court can do so if it's necessary. And I'm asking, how many times has the court in the last 75 years, how many times has the court put timelines? Hardly 2-3 cases. In rarest of rare cases has happened. And then why should we complain about it? We should welcome it, yes. Now throughout the country, all governors must give assent within 3 months. If they don't do, the litigant can go to the court. Is there anything wrong with that? Will heavens fall? Will entire administration go into chaos? Will there be a constitutional crisis? My answer is no, my lord. There is no reason to feel upset about it. You can only say on a principle, no, it is not that I will not be bound by any time limit. The Constitution doesn't say time limit, I will not be bound by it. That, in my humble submission, cannot be an argument. I'll go to the next point, my lord. Then my submission is, I've taken the plea of constitutional trust, which has not been taken.
The submission.
Yes, Roman 3. Lord, in 2.3, I'll read. Lord, over the weekend, there's an article by Professor Lon Fuller, where he talks of congruence. He talks of congruence. Congruence is the making of the law and the implementation of the law. If the law is implemented the way it was intended, it leads to congruence. If it is not done so, it leads to dissonance. So I'm just putting 2.3, Lordship may just see my proposition. Setting a time limit is essential for constitutional congruence. It makes explicit what was always implicit. What a lordship said, reasonable time. Give it okay, 3 months, 6 months.
If it doesn't act, then come to court.
No, or I'm going to come to constitutional bypass. Go to 368. Say reasonable, delete as soon as possible. Then, my lord, doctrine of constitutional trust. My lord, in Manoj Narula, I'll just read one passage from CY 2014. It's at volume 45, V45, page 17984. Very nice passage from Mr. CY, late CY. Here he talks, page 17984. It starts at 17984 under the subheading Constitutional Trust.
179.
17984. Basically, what they say is there is a belief that the highest constitutional functionaries will discharge their constitutional trust. 17984.
Starts from 17934. You are reading at page?
17984. And if your lordship permits me, my lord, I'll just read to 17983, para 82, which is the next point I made. I read para 82, my lord.
Para 82.
Para 82. May I read, my lord, para 82? Yes. In a democracy, citizens legitimately expect that the government of the day would treat public interest as the primary one and any other interest secondary. The maxim salus populi suprema lex, not only to be kept in view, but also to be revered. The faith of people is embedded in the idea of good governance, which means reverence for citizen rights, respect for fundamental rights and statutory rights. This is most important, deference for unwritten constitutional values. Deference for unwritten constitutional values. And my submission is one value is.
Exercise this constitutional power
Yes,
reasonably is inherent in the power itself.
correct. Correct. Your Lordship is right.
It need not be superimposed.
No.
So if the power exists, one has to read.
Yes,
the power,
like a Lordship said in Article 2.
the power
Yes.
that it must be exercised.
It's a power given in trust.
Time.
Yes, yes, Lordship is right. So I'm just relying on the passage deference for constitutional values. Constitutional values means once a government is elected and it passes a law, it passes a fisheries amendment bill, you have to pass it. That's the end of the matter. Now, please come to para 83, constitutional trust. My lord, the Honorable Supreme Court reproduces important passages from Ambedkar, Samshay Singh. I'll skip all that. What is interesting is what the late jurist Mr. Sirwai wrote in para 88. I'll just read the extracted portion. While discussing about the successful working of the cabinet form of government, H.M. Sirwai, the eminent author of Constitutional, observed. Now I'll read this, my lord. The Constitution does not guarantee that power would be wisely exercised by the executive. But as long as the political atmosphere remains what it is, the Constitution cannot be worked as it was intended to be worked. It has been said that the Constitution confers power, but it does not guarantee that the power would be wisely exercised. It can be said equally that the Constitution confers power, but gives no guarantee that it will be worked by men of high character, capacity, and integrity. If the Constitution is to be successfully worked, an attempt must be made to improve the political atmosphere and to lay down and enforce standards of conduct required for a successful working of our Constitution. So to lay down standards of conduct or lay down timelines for the effective working of our Constitution is the discharge of constitutional trust. This passage, Sirwai, is extremely important, my humble submission. Now I go to the next passage. Please come to 3.4. I have extracted from Sivanandam. This is High Court of Kerala. It was in a different context. But I'm relying on all these things to say that these timelines or these things which I've mentioned are nothing wrong, nothing unconstitutional, nothing warranting a presidential reference as such. In C.T. Sivanandam was High Court of Kerala. I'm reading 3.4, my lord. It was held in paras 44 and 45. In a constitutional system rooted in the rule of law, the discretion available with public authorities is confined within clearly defined limits. The primary principle undermining the concept of rule of law is consistency and predictability in decision making. A decision of a public authority taken without any basis in principle or rule is unpredictable and is therefore arbitrary and antithetical to the rule of law. The rule of law promotes fairness by stabilizing the expectations of citizens from public authorities. The principles of good administration require that decisions of public authorities must withstand the test of consistency, transparency, and predictability to avoid being arbitrary. So now, my lord, what is important is the consistency and predictability in decision making. As somebody said, not taking a decision is also a decision. So the point is, once the bill is presented, if the Supreme Court has enforced a particular standard, I think it's completely in consonance with our constitutional values and our constitutional provisions to make the cabinet system of government work. Otherwise, the cabinet system fails. You have an elected government, they form a cabinet, but they can't pass a law. It's a logjam, it's a constitutional deadlock. Now, the very important point I want to make is this judgment of natural resources in my humble submission, is, with all humility, my lord, does not lay down the correct law is my submission. Natural resources. That was your lordship saw in the aftermath of the 2G case. It has already been cited. Where I feel the judgment is incorrect and it is contrary to INRI Kerala Education Bill, is that it says that under Article 143, if a lordship is exercising advisory jurisdiction under 143(1), your lordships can evaluate and clarify another judgment, an earlier judgment. That's a very, very serious proposition to ponder. In an advisory jurisdiction under 143, can this court evaluate and clarify what is the law? I am saying that the judgment is incorrect. It is per incurium because it is contrary to what Chief Justice Das said in Kerala Education following Lord Spence. And it is obiter because in that case, the Attorney General said we are accepting the 2G judgment. We are not questioning the correctness of the 2G judgment. The Lordship sees the questions. In fact, what we have done is kindly come to, where is the chart? Lord, my friends have prepared a chart of all the 15 references which have taken place with paragraph numbers, what is held, etc. Please see that they have done a very marvelous job. 1126.
Yes.
Page 1126. Volume?
Same,
Same volume.
2.8.
Same volume. Oh yeah, after my, sorry. 112. This is after my written submission, sorry. Now, my lord, kindly see, from INRI Delhi Law's case, they have gone into what is the issue, what were the questions referred, what was answered. I am concerned with INRI Natural Resources, which comes at page . Well, there are totally 15 references, and each and every reference has been elaborately discussed. 141147. The Lordship knows, all of us know this 2G, all the licenses were cancelled. And the Supreme Court directed that the government should give spectrum not on this first come, first serve basis, but on auction basis. That was the. Now kindly come to the question that was said, referred to the larger bench, 5-judge bench under Article 143. Now please come to question 1, 2, 3, 4, where answered. Basically, they say auctions are not the only permissible method. There can be exceptions to auction. Now, if your lordship comes to the last column, last square in page 1147, lordship has got that?
Yes.
In the answers to the following questions. Lord, in this case, reference, the 2G judgment was annexed. And the correctness of that judgment was sought to be questioned. The judgment was an annexure. Now kindly see at the last row.
In the light of the statement.
Yes. Whether the judgment is required to be given retrospective so as to unsettle license issued by so-and-so, whether allocation and so-and-so, so all the questions were asked. In the light of the statement.
1147.
1147 bottom.
1147 bottom. In the light of the statement.
Yes,
Of the Attorney General that the government is not questioning the correctness of the 2G case, the court declined to answer. And all the remaining questions were relating to the correctness of the 2G judgment and the effect of that judgment. And throughout, right up to page 1149.
The same answer.
Same answer. So, having answered that, they need not have gone into the scope of 143(1). Completely unnecessary. Now, kindly come to what they have answered. They discuss Kaveri 1, Kaveri 2. Please come to para 65. At 1151. We are therefore, sorry. Yes, this is on the scope of 143(1). We are therefore of the view that as long as the decision with respect to allocation of spectrum licenses is untouched, this court is within its jurisdiction to evaluate and clarify the ratio of the judgment in the 2G case. For the purpose of this stage of argumentation, it needs little emphasis that we have the jurisdiction to clarify the judgment in the 2G case, irrespective of whether we actually choose to do so or not. Therefore, the fact that this reference may require us to say something different to that has been enunciated in 2G case as a proposition of law cannot strike at the root of the maintaining the reference. Now, what they say, this proposition, how they implement it is this, my lord. What they say is, we will declare a law contrary to what 2G said. We will declare the law, but we will not affect the decree. Kindly see, my lord, that's a very dangerous precedent. And that is discussed in para 60, yes. Yes. Para 61. From the aforesaid, he says it can't affect the decree. From the aforesaid, it is demonstrable that while entertaining the reference under Article 143(1), this court had analyzed the principles enunciated in the earlier judgment and also made certain modifications. The said modification may be stated as one of the mode or method of inclusion by way of modification without changing the ratio decidendi. For the purpose of validity of a reference, suffice it to say, dwelling upon an earlier judgment is permissible. That apart, one can't be oblivious to the fact of limited judicial review in the second judge's case, which is otherwise quite restricted, etc. My lord, my submission is, please come to para at page 1150. They say, kindly come to this last but one paragraph, the second limitation. Lordship has got that at page 1150, because this is seriously problematic, my lord. And subject to what the Lordship says, this cannot be the jurisdiction under 143. Kindly come to page 1150. The last but one paragraph, Lordship will say underline starts with in fact. Lordship has got it. In fact. In fact.
Overruling.
Yes, in fact, the overruling of a principle of law is not an outcome of an appellate jurisdiction, but a consequence of its inherent power. This inherent power can be exercised as long as a previous decree vis-a-vis inter partes is not affected. It is an attempt to overturn the decision of a previous case that is problematic, which is why the court observes that under Constitution, such appellate jurisdiction does not vest in this court, nor can it be vested by the President under Article 143. Then they say that we will make the point of law, but it won't affect the decree between the inter partes. My submission for Lordship's kind consideration is this. The jurisdiction under 143 is only to answer a question of fact or law referred to by the Honorable President to this court. My submission is the jurisdiction under 143 is not to clarify or evaluate. When you say evaluate, what do you mean evaluate? You're considering the correctness of an earlier judgment. With greatest humility, my lord, I will say the jurisdiction under 143 does not extend to this court evaluating or examining the correctness of a view. Just see what the consequence is. Indira Sawhney says 50% is the limit. Article 14 doesn't say 50%, 15 doesn't say 50%, 16 doesn't say 50%. You have fixed a percentage. They also go further and say 50% applies to promotion also. Now, can you have a reference to a bench of 11 judges to say, to evaluate and decide the correctness of Indira Sawhney? Answer is no. In case that judgment is wrong, then the remedy is Article 368. If that judgment has interpreted a ordinary statute, amend that statute, remove the basis. If it has interpreted the Constitution, then only remedy is 368. My submission is Article 143 is not a constitutional method to bypass Article 368. It will be a dangerous situation if the court says there is one judgment of 3 judges. It is, let's say, problematic. Use yours. So let us have a reference of 5 judges and we'll evaluate the correctness of that judgment. With great respect, my lord, that cannot be done under 143. If you go under 368, amend the law, delete as soon as possible, or say the governor will not be bound by any time limit. So I am only submitting the observations of this court, and I'll tell your lordship why. Even in the federal court, in fact, Mr. C, I was discussing with Mr. Supremecourt at lunchtime. Mr. CY, I've got a second edition. In re estate duty, what happened was very interesting. There was a case called in re levy of estate duty. AR 44 Federal Code 73. The Federal Court gave an advisory opinion. Advisory opinion under the Government of India Act. The High Court started following that advisory opinion as binding. The Federal Court says the High Court has fallen into an error in treating the advisory opinion as a binding principle of law. That comes in the Kerala Education Bill, and Kerala Education Bill says, yes, that is correct. And they cite Kerala Education, but let us not forget, in Kerala Education, they comment on the correctness of a federal court judgment. Supreme Court is supreme. Federal Court was not supreme. So Federal Court was subject to Privy Council. So in Kerala Education, Justice Das comments upon an observation of a federal court judgment. Nothing wrong with that. But my humble submission is, since your Lordship has got the occasion to see this reference, a presidential reference, in this case, we are basically testing the correctness of a view taken by a bench, though we don't mention it. We are saying, can you impose timelines and so on and so forth. I am saying that natural resources is a wrong law to say that you can evaluate and decide the correctness of another judgment in that court. So indirectly, you're making an intra-court appeal when there is none. It can't be done under 143. Suppose the 2G judgment, suppose there's a judgment of 2G by 2 judges. It comes before another bench of 2 judges. Following the Dawoodi Bohra pattern, they can say we doubt the correctness of it. Let it go to 3, let it go to 5. Of course, that doesn't bind my Lord the Chief Justice. He can constitute any bench he chooses. But I'm saying that if it's a 3-judge bench, then answer is not to create a reference and evaluate the 3-judge bench. Either it goes the Dawoodi Bohra route or it goes by the constitutional amendment. That's my humble submission. Yes. Now, coming back to my submissions, I was at page 'Yes. Please come to 4 point. But at 11:24, I'll just read that paragraph and just to reiterate what I said. One, two, three, last 2 sentences. May I continue? 1, 2, 3, last 2 paragraphs, last 2 sentences, and I'll go on. I have only one more point on constitutional conventions. Constitutional trust. Sorry, I have natural resources, yes. 4.1. In natural resources zones held under Article 143(1), the court has a jurisdiction to evaluate and clarify the ratio decedent in the judgment 2G case. It is submitted that this observation is both per incuriam and obiter dicta, because the Attorney General had repeatedly stated that the executive accepted the judgment in the 2G case. Further, the power to give an advisory opinion does not include the power to evaluate and clarify a judgment of bench of 2, 3, or even 5 judges. My submission is 143 is to answer a question of fact and question of law sent by the president. That's all. And that question of law cannot be a question of law that seeks to evaluate another judgment. That's my humble submission. Now, kindly see the next submission. I don't know if anybody has dealt with it. If so, I'll skip it. Number 1, under 143(1). What can be answered by this question is questions of fact and questions of law. Questions of fact and questions of law, which the president has a doubt. And the Honorable President wants the opinion of the president. Lordship sees all the 15 references which are given. Barring natural resources where the 2G was there but given up, nobody is evaluated or clarified whether it is in re sea customs, what's the scope of Article 285, or in the Delhi laws, what's the scope of delegated legislation? All these are questions of law which the president had a doubt and the president makes a reference. My submission at 4.2 is this, Lord. Now, question of law is there in CPC, substantial question of law. In every tax statute, there is a question of law. High Court only on questions of law. And I was surprised to note, Lord, that under section 100 before 76, there was no reference to question of law. That was only in section 109. But in 100, they introduced substantial questions of law. Meenakshi Mills, Justice Venkatramayya has discussed at elaborate length what is question of fact, what is question of law. I am not on that. I am on the point that if the Supreme Court has delivered a judgment on a statutory provision or a constitutional provision, then that is a law declared under Article 141. My Lord will see the presidential reference in this case. The questions referred are issues framed by the two-judge bench in this very case. For example, the first question which is there, what are the constitutional options? Issue number 1. If a lordship takes question number 2, it's issue number 4. So I'm putting a proposition of law. If the Honorable Supreme Court, because it's a what they call polyvocal court, you can have bench of 2 judges, 3 judges, 5, but whatever it may be, it is Article 141. So my submission is, if a particular bench has framed an issue, answered the issue as a question of law, then on that point 143(1) will not arise, because there is no other, because the president has to only follow that judgment, that's all. Or parliament has to amend the constitution or amend the statute, whatever it may be. So I'm putting forth the proposition that 143, the lordship sees that section, just 1 minute. Yes.
President.
My friend puts it very, Sadan put it better. Sorry. My friend Mr. Farasar put it quite well. He said, once the question of law is answered, it's no longer a question, it is the law. Then there is no question of law. It says, if any time it appears to the question that a question of law or fact has arisen or is likely to arise, if such a nature. If a question of law has arisen and it has been answered by the court, then 143(1) will not. Sorry, man.
Yes.
Yes. I'll just go back to my submissions. No, my lord, because since your lordship is now laying down the law for all future times to come, if there is a declaration of law by the Supreme Court under Article 141, that should not be a ground for a reference, is my humble submission.
We did not come to argue as a preliminary objection that the reference is not maintainable. We have been hearing on all the 13 questions.
No, I was told your lordship said did not go to maintainability. So I'm not saying it's not maintainable.
No, we have what on the maintainability?
Everybody argued, Manoj, on that side, this side.
All
It
right.
was argued. I didn't want to interrupt, but
Yes.
it was asked.
No, I'm only saying that the reference is there. What I'm submitting is, if the question.
You are not on maintainability.
I'm saying that if one question referred to the honorable court has been already answered in a judgment, it can no longer be a question of law. That's my submission. So suppose there are 12 questions, hypothetically, and 6 questions have been answered in a judgment. Those cannot be the subject matter of 143(1) is my question. Because there could be some questions which are open. That's why I'm not getting into, but I don't want to be hyper technical. Today we have to answer a very important issue on reference jurisdiction. And whatever law lordship lays on is going to be there for the next 15, 20 years. That's what I'm submitting. So my submission is, because what the president refers are questions. And those of us who have been, again, going back to tax, old 256 lordship, no, when lordship were juniors at that time, there used to be a reference jurisdiction. High Court did not have appellate jurisdiction. It will go to the High Court for the reference as an opinion. Based on the opinion of the High Court, assessment order is then passed. And the Honorable Supreme Court has said in Lala Bansidar's case, if there is a reference, then there is no question of any merger and all that. The advice is given by the reference answered by the High Court and the assessment is complete. And even though the matter goes to this High Court for a reference, the tribunal continues to be seized of the matter. It's not that the record has gone to the Superior Court like a first appeal. So High Court answers the question of law,
Then after a final order is passed.
and then assessment order is passed in terms of the assessment, unless it's modified by the Supreme Court.
Assisting.
So my humble submission is, what is the meaning of 143 questions of fact and questions of law? If it's a question of law answered, then that can't be the subject matter of 143(1). Now kindly see, my submission is para 4.2. Once the president will require an opinion only on a question of law on which there is a doubt. 4.2, Malad, just 2 minutes. Once a judgment is delivered, the only way its basis can be challenged is by a constitutional amendment, Article 368. That is slightly, if the judgment is on a constitutional article. That's why I said, Indira Sani, the Supreme Court said 50% is there. They also said 50% will be for promotion also. What did Parliament do? 77th Amendment, 16(4)(a). Promotion will not be, 50% won't apply to promotion.
Indira Sani said that the reservation will not apply to promotion.
50% limit applies to promotion also.
Indira Sani said that
No, not promotion. It's not apply to promotion. So it will apply to this thing.
it
Then
applies only to appointment and not for promotion, and therefore
Yes,
the
16(4)(a)
first
came.
amendment.
16(4)(a). 16(4)(a) amendment came. Similarly, carry forward rule. They said the reservation will not take into account that carry forward rule. That also was, so I'm only submitting, you could not evaluate and correct
It's for the parliament to correct according to.
so that by constitutional amendment.
Yes, by constitutional amendment,
Yeah, yes,
if they want to overcome the judgment of the revision bench, they can't do it by way of reference.
because it's a
The
360.
only way available to them is by way of the constitutional amendment.
Because they've interpreted the constitution. That's why the Maratha reservation is we succeeded on 2 rounds, because it can't be done by a Maharashtra legislative act. That 50% limit can't be crossed by a Maharashtra law. Now again, my friend argued on this, adding to the list of scheduled castes.
That is again going on before Bombay.
Which one?
Bombay High Court, Maratha reservation.
I concluded my arguments, Varun. No, again, 4th round is coming after the recent. Both of us were there, both of us were there in Bombay and then Supreme Court.
Full bench.
Then, my lord, it came to Jayashree Lakshman Patil here. And where, my lord, once the bench held that under 342, the state can't amend the list. Again, the constitutional amendment.
What is your answer to 145(3),
Huh.
which requires that any question with regard to interpretation of the constitution
Yes.
has to be heard minimum by 5 number of judges?
My submission is, please see the provisor to that. Please see the provisor to 145. Yes.
They provided that.
His lordship will, my friend says, please read 145(1). Yes, that says yes. Now kindly come to 145(2). Subject to the provisions, the articles may fix a minimum number of judges who was to sit for any so and so, so and so. 3, the minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of the constitution, or for purpose of referring any reference under 143 shall be 5. Now please see the proviso. Provided that where the court hearing an appeal under any of the provisions of this chapter other than Article 132 consists of less than 5 judges, and in the courts of hearing of the appeal, the court is satisfied that the appeal involves a substantial question of law as to the interpretation of this constitution, the determination of which is necessary for the disposal of the appeal, such court shall refer the question for opinion of law constituted as required by this clause for the purpose of deciding any case involving such cases, and shall on the receipt of the opinion dispose of the appeal and so on and so on.
So therefore, then the court was required to refer that question to.
No, if the court is satisfied, my submission is first twofold. If it's a writ petition under Article 32, and there's a bench of 2 judges before whom the challenge comes, there are any number of cases where this honorable court in sitting in 2 and 3 have struck down a particular law under article constitutional provision. They've interpreted the constitutional provisions. I can give any number of cases it has done so. So what I'm saying is under 145, the minimum judges who are to sit for the purpose deciding any case.
Struck down the constitutional provisions.
Yes. Or it has upheld the provision. They've heard constitutional issues. The entire issue of service tax, All India practitioners case. It was heard by 2 judges. I'll give so many other examples. The cooperative society was struck down by 2 judges. Remember, this 145(3) has come at a time when the Supreme Court used to hear all matters en banc, 5. Now, over a period of time, it's not.
Cases, request was made that refer it to the larger bench.
Which one?
Here, the learned AG did make a request.
But if it is not, the way I referred to the proviso was, the court hearing the appeal, let's say the appeal can be an Article 32 petition. Suppose a reason is made that this matter should be referred to 5 judges. And the court says, no, not necessary to refer to 5 judges. Jai Shri Lakshman Party, 3 judges, right?
5 judges.
No, no,
Five judges.
which are heard by, Nageshwar Rao, Hemant Gupta and 3. I think your lordship also know.
It's 5.
Hemant Gupta and Ravindra.
It's 5 judges.
Ravindra.
Five judges.
It is
One judgment.
appeared through virtual
The
hearing.
next
during
round,
COVID.
the next round came. What we argued was this was thought to be referred. We argued that since the matter is already concluded, though it involves interpretation, there is nothing further to answer and so on. So I'll give any number of cases where 2 judges benches, 3 judges benches have heard matters of constitutional interpretation. And in any case,
Just one.
at best, it can be an illegality or fatality.
Ashok Kumar Thakur, which is 2007, 6 SEC page 1, if I'm not wrong. Before it was
Last
referred,
number.
right, 2 judges to 5 judges. The 2 judges stayed section 6 of the reservations, Central Reservations Act. By 2 judges.
And I would submit, Brother, to answer 145(3), my proposition is this. Sorry. I'll put it for Lordship's kind consideration. 145(3), over the years, 145(3) is not taken as a necessary mandate. Not constituting a 5-judge bench is not an illegality or irregularity.
When a specific request is made to a bench,
Hmm.
that these matter requires interpretation of constitutional provisions. Anyway, we are not sitting in an appeal. So
Yes. Understand. They go for a review. Go for a review. You review curative, whatever it may be. No, I'm only saying that you can't take up at now in 2025 and say a bench of 2 judges decide a constitutional provision. They have not struck down any particular provision. They've only said, please see the judgment below. What have they said? They've interpreted, Lordship, see the particular judgment also. Have they struck down any particular provision? No. They have said it should be done in 3 months. If it's not done in 3 months, you can approach the court. And kindly see, and deciding
petitions to the law. You can't come with.
But one more point I'll raise, since we're on a principle law, not put this particular judgment. Now the question is, suppose tomorrow I file a writ petition challenging a particular provision, or from the Madras High Court or High Court it comes on appeal. It involves a question of law. I raise an objection saying it should be heard by a bench of 5 judges. A bench of 5 judges. I raise an objection. Suppose the court feels that yes, it requires interpretation, yes. Now in this case, it should be a case involving a substantial question of law as to interpretation of the Constitution. Suppose the court is going to rely on a series of precedents and decide, it may feel it's not necessary to go to 5 judges. I've got enough case law to take a decision on that particular point of time. I'm only saying that let's not create a situation. Otherwise, we will not be able to decide many matters because everything will wait for 5 judges.
yes.
Everything will be for 5 judges. But I don't want to go on this fear psychosis. I'm only submitting that there is a practice of this court of 2 judges and 3 judges deciding cases of constitutional law. Here it talks of involving a substantial question of law as to the interpretation of this Constitution. My humble submission is, this court has only said as soon as possible is equal to 3 months. That's all. Nothing. It has not struck down some great constitutional provision by 2 judges. No. I can understand like Indira Sani decides multiple questions by bench of 2 judges. Yes. That's my submission. Yes. How do you deal with objection of validity? Yeah. Yes. And one more thing, my lord. In para 239 of the judgment, his lordship says that our interpretation is not to be taken as an interpretation of 200, but to be considered as guidelines to attract judicial review. I'll read that passage, para 239 of the two judge bench. Any time limit in the exercise of powers in terms of Article 200 of the Constitution should not be construed as timelines laid within the edifice of the provision, but should be understood as timelines that serve as a lodestar for the purpose of exercise of judicial review by the courts, a benchmark tool to aid and enable the courts to ascertain if any action or malfeasance has occasioned the exercise of such powers. So, but I'll just go to the other part. But then your lordship will have to frame a question that if a question of substantial import of constitutional interpretation comes, substantial question of law, constitutional, should it be heard by a bench of 5 judges? If that is the answer, then we are going to have a question where there will be a threshold limit first deciding. Is there a substantial question of law? If the answer is yes, it has to necessarily go to 5 judges. If your lordship feels that should be there, so be it, my lord. Now kindly come to, but I'm only submitting that could lead to serious problems of areas in the long run. Now, kindly come to 4.3. A chart is annexed which sets out the details of 15 references under Article 143(1). There has never been a reference to take up a question of law which has already been answered. Chart containing details of all 15 references is marked as Annexure 1. Now I come to my final submission on constitutional conventions. Now, my lord, the Constitution doesn't provide for everything. Practice adopted by constitutional functionaries, be it the judiciary, the legislature, the governor, the president, that they set out conventions which are to be followed. Our Supreme Court has said a convention taken over time is as good as constitutional law. Constitutional convention also amount to constitutional law. Now I'm asking myself the question. Is there a constitutional convention of approving a bill at the earliest opportunity? My submission is Article 111 and Article 200 are mirror images, barring minor differences. Both talk of assent to bills. They don't talk of scrutiny of bills, examination.
You have already argued that.
No, I'm saying constitutional convention. So I'm just quoting a passage from May, and I'm going to say that there's a convention. I'll put this properly, my Lord the Chief Justice will ask the question. I'm saying that if there is a constitutional convention of the president giving assent to the bills, and very, very few examples are there where it has been withheld for some small period of time. If there is a convention under Article 111 to approve the bill at the earliest, as soon as possible, which is also a term used there, the same convention must apply to Article 200 also. Because what the governor is to the state, the president is to the country. In a federal setup, the governor performs the same role as my friend put it, I'll show his passage later. In a Westminster form of government, in a presidential form of government, the president is also the head of state. But in a Westminster form of government, there's an elected government and there is a head of state, a symbolic head of state.
Titular head.
A titular head or a titular head, like the queen or the monarch or the president or the governor. He is not just for a mere symbol, because governments will come and go, but the president is there, the governor is there. He symbolizes the state. He is the head of the executive. He symbolizes the state. He becomes the supreme commander. All those things come which have followed the British pattern. Now I'm going to come to two passages from Erskine May's 1924 edition. It is not there now because now they have passed a Royal Assent Act in 1967. But yes, but what is the convention? Please come to para. Very interesting passage from Erskine May. At para 1.5, just two more passages and I have done. Page 1120. The constitutional provision Lordship has got it. All in Lordship, page 1120. Extract from May is very interesting. The constitutional provision to grant assent has been borrowed from the Westminster model. The royal assent is to only complement and perfect the law. The following passages in Erskine's Mill's Treatise of Law, Privileges, Proceeding, Usage in 1924 are important. Page 430. But I've extracted that page also. When bills, either public or private, have been finally agreed to by both houses, they only await royal assent to give them, as Lord Hale says, the complement and perfection of a law, and from that sanction they cannot be legally withheld. Now 433 is even more important. The form of words used to express denial of royal assent would be le roi se assuera. Assuera means the king withholds, the king is going to consider. That's the French term used before 1967. The necessity of refusing the royal assent is removed. Now this is very important. The necessity of refusing the royal assent is removed by the strict observance of the constitutional provision that the crown has no will but that of its ministers. Aid and advice. The crown has no will but that of its ministers, who only continue to serve in that capacity so long as they retain confidence of power. This power was last exercised in 1707 when Queen Anne refused assent to a bill for settling the militia in Scotland. Now, we're coming back to my page on constitutional conventions. I just read that passage and I've concluded now. Para 5.1. Just 5 minutes more. The grant of assent by the president is set out in Article 111. Barring very rare exceptions, the president has followed the UK pattern of not withholding assent. This practice of president assent not being withheld must be followed by governors. There cannot be one constitutional convention for the president and another for governor when the ambit and scope of Article 111 and 200 are the same. Conventions play an important role in understanding the real purpose and function of a constitutional provision. I've given the footnote, but I won't trouble Lordship. I've given the para number also. British conventions assume special significance in understanding the parliamentary system of India, since it's akin to the parliamentary system of England. In the second judge's case, it was held that the written constitution cannot provide for every eventuality, and hence the gaps present in the constitutional provisions are to be filled by constitutional conventions. This Honorable Court also held that there is no distinction between an established constitutional convention and constitutional law, as they are both binding in the respective fields in which they operate. When it is established that constitutional convention exists, it would be enforced in a manner similar to constitutional law. Now, UNRO's case is important. Article 111 and 200 place a president and governor in the same position as the king/monarch of England. In UNRO versus Indira Gandhi, it was held that Article 75(3) has to be interpreted, take the judgment, with the conventions which prevailed at the time the constitution was framed. Please see that judgment, Lord.
That was already been read to us.
UNRO para 3? All right. So I'm submitting that if 75(3), if the convention of 111 is not to withhold assent, please apply the same convention to 200. Because what conventions applies to one provision must also apply to a pari materia provision of the constitution. That's all. Now, Lord, from Mr. Shadan's two passages. Yes, he wanted to. Two passages.
Your chart shows 45 minutes, but you already taken 80 minutes.
Sorry, but he has one interesting passage he mentioned about one book. I will just leave it again. Just take 2 lines I can show because he wanted to. I'll read that one. What just permit me. Please come to 1155 with the same page and I'll stop with that. Yes. Please come to page 1156.
He's not shameless.
A nominal head of state, Lordship's got it? A nominal head of state, unlike the head of government, has only 3 powers. Page 1156, para 5. Then extract is there. Please come to para 1157. And the bold portion, just 3 lines I'll read. Lordship has got that?
Yes.
To state the matter shortly, by Walter Bajeho. To state the matter shortly, it is the role of a sovereign. The sovereign has under a constitutional monarchy such as ours, 3 rights: the right to be consulted, the right to encourage, the right to warn. And a king of great sense and sagacity would want no other. He would find that his having no others would enable him to use with singular effect. He would say to his minister, the responsibility of these measures is upon you. Whatever you think best must be done. Whatever you think best shall have my full and effectual support. But you'll observe that for this reason and that reason you propose to do is bad. And for this reason and that reason you do not propose is better. I do not oppose. It is not my duty to oppose, but I observe that I warn. So the role is the right to consult, right to be consulted, the right to encourage, the right to warn. Therefore, my humble submission is, my lord, as far as this reference is concerned, all these questions have been answered, and the points that have been raised, since they're already questions of law answered, these questions need not be answered under Article 1, should not be answered under Article 143(1). Particularly that in the natural resources is the most problematic judgment of saying under 143, a referral bench, an advisory bench can evaluate and clarify a law would be very dangerous, deeply obliged.
Take about 10 minutes.
Only one council for one state.
I'm appearing for internet also.
No, no, we have.
10 minutes.
If you permit intervention of one political party, we'll have to have
Only one intervention is allowed.
No, no.
We have not yet started. even.
Not yet, my lord.
They are not hearing Mr. Gopal Singh.
My lord, I have 5 minutes, I'll place it.
We are no, if we permit one political
Only
party.
new facts, my lord, nothing else. My lord, other,
No facts, we are only.
on the law, my lord.
Let the states complete, because state of Telangana has yet not been heard.
My lord, after them, then I'll make my submissions.
We don't know, we.
5 minutes, my lord, I'll place it, my lord.
We have a sequence which we've been following, Manoj.
Sorry.
So Reddy is supposed to be next. We're following.
Mr. Wilson, but then he's been shown as an intervener, so.
Mr. Reddy is next.
My lord, on
As per the
our side, we have requested many interveners not to come.
Yes.
My lord, I'm only placing, my lord, 2 discussions, my lord, constitutional issues, my lord.
But
Article
we have heard the state of Telangana extensively.
My lord, 175, my lord,
From Tamil Nadu extensively.
my lord, my lord,
Let the state of Telangana address.
yes,
Let
Lord, I'll
the
wait, my lord. Lord, as per sequence, my lord, my name is there. Lord, we are.
We know, but then we are not
No
allowed,
reason, my lord, for this reference.
we are not allowed the intervention application.
Lord, we are the sole reason for this reference. My lord,
Maybe, but then state of Tamil Nadu has opened the argument.
we thought, my lord, some
No, no.
important points, my lord.
One political party, then we'll get hundreds of political parties.
Lord, one intervention is already allowed, my lord, that's why. Sir Gopal Sankaranarayan is appearing for them.
Who?
Sir Gopal Sankaranarayan. Yeah.
No,
5 minutes, that's all, my lord. 5 minutes.
For the Gopal sir and
One for my
Five
five
minutes.
interventions were allowed on the first
Allowed
day.
already.
We have all been waiting patiently. Somebody, because the opportunity has been lost, is now coming on an
No, no,
intervention.
sir,
That's
I'm
what is
also there,
happening.
sir, for the day 1, sir.
No, no, but it's,
Since
you
8
are
days
saying
we are
that the
waiting
case
for-
arises because of state of Tamil Nadu. The arguments were opened by state of Tamil Nadu, and we have heard extensively for more than a day.
First we'll complete states, let him start.
Let
Five
the state complete.
Lord, I leave it to your lordship.